أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على رسول الله وعلى آله وبارك وسلم. Assalamu alaikum, dear students. I welcome you all to another session of video lectures for online studies. Today we'll have lecture number 5. Lecture number 5. In this lecture we are going to start chapter number 3, and chapter number 3 is mainly talking about offer and acceptance. Offer and acceptance is one of the most important and one of the first essentials of a valid contract. So inshallah, in this chapter we'll have discussion on offer, the essentials of a valid offer, the revocation of the offer, and then we'll have discussion on acceptance, the essentials of a valid acceptance. This chapter has been divided into 3 lectures. Lecture number 1 talks about the offer and its essentials. Lecture number 2 talks about the revocation of the offer, and lecture 3 is about the acceptance and its essentials. So today in lecture number 5 we'll have discussion on the offer only. We'll have discussion on offer and its essentials and the revocation of the offer. So let's begin. What is an offer? Section number 2 defines offer as a proposal when one person signifies or shows to another person his willingness to do or not to do something, or abstain or give up from doing anything, with a view to obtain the assent of that other to such an act or abstinence. He is said to make a proposal. In simple words we can say, first, offer and proposal are same thing. The word offer and proposal in business law, it's the same thing used for the same purpose. You can call it a proposal or you can call it an offer. What is an offer? In simple words we can say, when one person shows his willingness, shows his willingness to do something or not to do something to another person, and the purpose is to know the assent of that other person. So such showing of such willingness to do something or not to do something is called basically offer or proposal. For example, I will say, I would like to sell my car. For example, I say to Ali that I want to sell my house. Do you want to buy? So when I am saying that I want to sell my house to you, that's I am showing my willingness to do something. And what is that doing something? To selling of my house. And the purpose of this showing willingness is not to impose. It's to find out the willingness of that other party. I want to find out if he wants to buy my house or not. If he agrees with me to buy my house or not. I want to know what is his willingness. Right? So when a proposal or when an offer is made with the assent here means the main purpose. Right? The main purpose should be to know the willingness of that other party, the opposite party. If the main purpose of the proposal or offer should not be imposition. It should not be imposing someone. It should be to find out the willingness of other. Right? So such act is called offer or proposal. Right? Offer can be a simple word. It can be a sentence. It can be one page. It can be multiple pages. It can be a long, like 100 pages proposal. So it depends upon contract to contract. It can be an action as well. Inshallah, later on we will study how an offer can be an act, how an offer can be a word, can be a sentence, can be, for example, a page, can be multiple pages. Right? So the main purpose is that offer means showing willingness to other person for doing something in order to know the willingness of that other person. So such showing of willingness is called offer. It means that when a person shows his willingness to do or not to do something to obtain or find the consent, right, of the other person, it is considered a proposal. So when there is an offer, there are two parties. The first party is called offerer. The second party is called offeree. The person who makes an offer is called offerer. The person to whom the offer is made is called offeree, or the person who will be accepting the offer, or the person who may reject the offer is called offeree. When the offer is accepted, it becomes a promise, right? When the offer is accepted, it becomes a promise. So the person who gives the promise is called promiser, right? So offer is from one side and acceptance is from the other side. If the offer is accepted, then there is an acceptance. If the offer is rejected, there is no acceptance, right? All right. So that's all about the offer, the definition of offer. Hope you guys have understood the meaning. I've tried my level best to explain it as simple as possible. So what are the essentials of a valid offer? What makes an offer valid? What things should be present in an offer to make it valid from the legal point of view? There are 7 things, 7 elements of an offer. An offer must contain all these 7 things. That's why these are called the essentials. If one or more of them are absent in an offer, that offer is not valid. If the offer is not valid, the acceptance could not be valid. If there is no offer, there is no acceptance. When there is no acceptance, there is no contract. So that's all about, there is a big logic behind an offer being valid, because everything starts from the offer in a contract. If the first step is wrong, all these steps are wrong and invalid. Therefore, we have to be very careful. While making an offer, we have to keep in mind that all these essentials mentioned here, they're present there. If we are to accept an offer, we have to see whether that offer contains all these essentials or not. Okay, so let's begin. I'll first try to conclude all these 7 in shortest possible way and as simple as possible. Then we'll go through all the slides and explain the slides one by one as well. So first essential of the valid offer is expressed or implied. An offer could be expressed in words, written, or spoken. An offer could be expressed in words, written, or spoken. For example, I write to someone on a piece of paper, or maybe on the email, or maybe on text message, and I show my willingness to buy something or to sell something, right? So such an offer is called express offer. It could be written in words, it could be spoken in words. The second thing is implied. An offer could be implied. Implied means action. It could be action. For example, you enter into a barber shop and you sit on the seat where barber seats people in order to cut the hairs and shave the beard, etc. So when you sit on the seat of the barber, basically you are making him an offer that I want to cut my hairs, right? But you don't say that, you show it by action. And when he starts cutting your hair, that's his acceptance. So sitting on the seat of the barber is basically an implied offer. Similarly, you may have seen on the airports, there are people who carry baggages with the passengers, and they are given, they charge a minimum amount of money. So when a carrier comes and he holds your bag, this action from his side is basically an offer. He wants to offer you, he wants to get into a contract with you, and that contract is that he will carry out your luggages to the parking lot and you will pay him, right? So when he holds the bag, puts it on the trolley, this is basically an offer, implied offer from his side. So when you say nothing, it means you accept the offer, right? Or you say okay, that's also accepting the offer. Next one is legal relationship. Legal relations. An offer is offer only if it is made for business purposes. Here legal relations means business purposes. The offer is never for social purposes. Social purposes, we call them invitation, right? So offer is always to create business relations with the opposite party. Means there is always a consideration, there is always something given or taken, there is always a benefit kept in mind, right? So making an offer to someone should always be to take a benefit, to get a reward, and also the other side should also have the reward. So there is always something given or taken, there is legal consideration present in that. So legal relation here means that the offer should be made in order to enter into an agreement, business agreement, to create business relations with the opposite party. The third one is definite and clear. The offer should be definite. Definite means the words that you use while making an offer, those words should not have meaning, more than one meaning. The words should be definite, defined, and clear. Whatever you make an offer for, the quantity, the quality, the color, the brand, etc., etc., everything should be definite and clear. In case if there are words having multiple meaning, you have to identify at the beginning that what does I mean by using this word. So that's very important. And if any offer has indefinite words and is unclear, that offer is not a valid offer. For example, I tell someone that I want to sell a motorcycle. Do you want to buy? So this offer is neither definite nor clear, because I said a motorcycle. So a motorcycle, what motorcycle? Is it small motorcycle? Is it big motorcycle? What is the cc of the motorcycle? What is the color of the motorcycle? What is the makeup of the motorcycle? It's not clear. The price is not clear. So this offer could not be a valid offer. What is the valid offer? The valid offer is that I want to sell the motorcycle made by Honda 125cc, red color with the specifications and this price. Do you want to buy? So this now is a definite and clear offer, right? So the offer should always be definite and clear. The fourth one is specific or general. The offer could be specific to one individual or to a group of individuals. So from the offer, when making an offer, while making an offer, you have to specify it. You have to make it clear whether this offer is only to a specific person or it is only to a specific group of people, right? Or it is a general offer to everyone who fulfills the conditions can accept the offer, right? So your acceptor, your offeree should be specific or general while making an offer, right? If the offer is specific, only that specific individual or group of individuals can accept. Anyone from the group of their individuals can accept. If it is general, it could be accepted by anyone from the audience, right? So your audience should be clear from the beginning whether this offer is for general people or this offer is specific to one individual or a group of individuals. Communication with offer. It's also one of the most important essentials of the offer. the offerer is responsible to communicate the offer with the offeree. Means, to whom this offer is communicated, only that individual can accept the offer. To whom the offer is not meant, not communicated, cannot accept the offer. Right? So while making an offer, we have to make sure that we should have communicated our offer to that relevant, specific, or that relevant individual. We have to make sure that the offer is communicated. We cannot put a negative condition in the offer, right? Negative conditions could not be put in the offer, but positive conditions, we can put positive conditions in the offer. We'll talk about the negative conditions and positive conditions in the offer later on in the slides, right? So these are the 7 essentials of the valid offer. So let's go ahead and explain them one by one. An offer may be made by words or conduct. The words could be spoken or written, as I earlier mentioned. An offer which is made by words spoken or written is called express offer, while an offer made by action, that called implied offer. The implied offer appears from actions, conduct of parties, course of dealing, or circumstances of the case. So there are 3-4 things: action, conduct of parties, course of dealing, and circumstances. These 4 things makes an implied offer. For example, Mahmoud says to Nadeem that he sells his motorcycle to Fahim for 40,000 of money. It is an express offer because we say Mahmoud says, so he has spoken to Mahmoud. Example B, a cart carrier carries the luggages of Bilal without asking to do so. Bilal allows him to do. It is an implied offer. So that is the implied offer. Number C, B is running a bus service to carry passengers at scheduled fares. This is an implied offer by the company. For example, there is a bus, and everybody knows that from one stop to other stop, the rate are clear. When bus stops, people get into the bus, and then when they drop off from the bus, they pay. There is no like words spoken here, but this is an implied offer. When bus stops, this basically is an action, or this is a course of dealing, or this is circumstances of the case, right? This is the conduct of parties. Bus stops, you get into the bus. When bus stops, you pay and then drop off. So that's how an implied offer is made and accepted. Next, legal relation. The offer must be made to create legal relations, otherwise there is no agreement. Legal relations here means that there should be a legal relationship between legal obligations between the parties. Though after offer is accepted, the obligations which creates under this offer must be legal, right? Must be according to the law, not against the law. And there should always be a business between the parties, not for social affairs, right? Offer is only and only for business affairs. If an offer does not give rise to legal obligation between the parties, it's not a valid offer. In business transactions, it's presumed or supposed that the parties intend to create legal relations. When we are in the business context, whatever offer we make, it's what? It's a business offer, it's a legal offer, because this offer is to create legal relationships between the parties, and this offer gives legal obligations to both of the parties, right? So 2 things should be remembered here. One, legal relation. Legal relations means business relations. The second thing is legal obligations, right? The obligation assigned to the parties under this offer should also be legal. There is example: A invites B to a dinner and B accepts the invitation. It does not create legal relation because this is social matter, right? There is no agreement. A offers to sell his house to B for 1 million Afghani and B agrees. This is an agreement because parties intend to create legal relations, right? It's a business relation. For me, 1 million Afghani. For Ahmad, 1 million Afghani is beneficial. For Bilal, house is beneficial. So there is something given or obtained. Okay. Next, definite and clear. An offer must be definite and clear. In terms of an offer are not definite and clear, it cannot be called a valid offer. There is an example. Ahmad has 2 cars. He offers me to sell one of them for 200,000. So it's not clear which one. That's why this is not a valid offer. We say the offer should be clear and definite. Which car? The car should be defined. The car's specification should be defined. Then it becomes a valid offer. Otherwise, it's not a valid offer. Ali has 3 mobiles: Nokia, Samsung, and iPhone, and the models are also clear. So he offers to sell Nokia N9 for 10,000 Afghani. It's a valid offer because which phone, which model, and what price. It's clear. That's why it's a valid offer. If you want to make it even clear, you have to say which color. Even the size of the phone could also be specified here. It becomes even better, right? An offer may be specific or general. When an offer is made to a specific person or group of persons, it's called specific offer. Such an offer can be accepted only by the person or persons to whom it is made. The second type of offer is general offer. General offer is made to public in general, and it may be accepted by any person who fulfills the conditions mentioned in it, right? So that's how I explained earlier as well. So for example, Mahmoud makes an offer to Nasim to sell his bicycle for 10,000 Afghani. This is a specific offer now. Only Nasim can accept. Nobody else can accept this offer. There is another example. Ahmad announces in newspaper a reward of 10,000 Afghani for anyone who will return his lost documents in his car. So that is a general offer. Anyone who found the documents and brings back to Nasim, to Ahmad, he will pay him the 10,000 because this is a general and open offer, right? Next one we have is communication with offeree. An offer is effective only when it is communicated to the offeree. If an offer is not communicated to the offeree, it cannot be accepted. An accepted offer of offer without having knowledge of such offer is not valid acceptance, and does not create an illegal obligation. Thus, an offer which is not communicated is not a valid offer, right? For example, there is a good example as well regarding communication with offeree. Let's see the example, then I'll also have another example for you. There is someone by the name of G, right? Gauri and Lalman, there are 2 people. Gauri nephew was missing from home. He sent his servant Lalman in search of the boy. When the servant left, Gauri announced a reward of $500 for anyone who gives information about the boy. The servant, before knowing this announcement, has found the boy and informed Gauri. Later he claimed the reward. He failed on the grounds that he could not accept the offer unless he had the knowledge of it. Same is the case, for example, someone loses his documents and you have found it, right? You return to him. You did not know that that person has announced a reward. You return to him, and later on you came in to know that this person has announced a reward, and then you go back and claim the reward. You cannot do that because you found the documents without having the knowledge of his reward announcement, right? Therefore, the offer is not communicated with you, so you cannot accept it, right? When you have in knowledge that the person has announced reward, and then you find the document and return, then you can accept the offer because the offer is communicated with you. So that's one of the most important essentials of offer as well. A negative condition. An offer cannot contain a condition that offer would be considered as accepted. This is negative condition, right? The offer would be considered as accepted if acceptance is not communicated up to a certain date. You cannot put this condition with an offer, right? شما گفتن نمیتونی که مثال اگه شما تا این روز آفر ما را قبول نکردین ما این را قبول شده حساب میکنم. این منفی کندیشن است، شما این را در آفر مانده نمیتونین. صحیح؟ دست نشید که شما منفی کندیشن شده تو واجه که در وقت پر دمات احوال را نکه نو زه به دا پوه شم چې تاسو ما آفر قبول کړی. دا منفي کنډیشن دغه شرط مونږه په آفر کې نشو ایښودلی. صحیح ده؟ Understood or not? So what should be a positive condition? The positive condition is that if you does not reply to me to a certain date, the offer will be considered as rejected. This is a positive condition. We cannot put this condition, and that's number 7, right? Number 6 is negative condition, and negative condition is that you cannot specify the acceptance of an offer to a certain date on somebody and impose it that should be considered as accepted, right? There is an example. Ahmad wrote to Bilal to sell his house, adding that if he did not reply within 5 days, the offer would be considered as accepted. This is a negative condition. There is no agreement because the offer is invalid. When the offer is invalid, there is no offer. When there is no offer, there is no agreement at all, right? Because offer, when accepted, becomes a promise. Promise becomes an agreement. Agreement becomes a contract. When there is no offer, there is no promise. When there is no promise, there is no agreement. When there is no agreement, there is no contract, right? Number 7, condition in offer. An offer may include any condition in his offer without negative condition. Negative condition is explained earlier. This is no contract unless all conditions of the offer are accepted. I mean, if there are positive conditions in the offer, the offeree must accept all the conditions, right? If he accepts the offer with all positive conditions, the offer will be considered accepted. If not, if he rejects one of the conditions in the offer is considered rejected, right? So positive condition could be anything. For example, one of the positive condition is that, for example, a job, when there are job offers, there are there is TOR, there are specifications. So anyone who fulfills all those specifications can be given a job. Even if you fulfill all the specifications and you fail in written test, that's all. You cannot accept that offer. Even if you pass the written test and fail in the interview, so that's one of the conditions of that offer. You did not fulfill that condition, you cannot accept that offer. If you fulfill the education requirement, the experience requirement, the test requirement, the interview requirement, you fulfill all of them, then you can accept the offer, right? So that's one of the other important essentials of the valid offer, right? Now let's go ahead and talk about the revocation. Revocation, what does revocation means? Revocation here means cancellation. How can we cancel an offer? How can we revoke an offer, right? What are the conditions for revoking an offer? An offer may be revoked in any of the following ways. There are 10 different ways of revoking or cancelling an offer. Sometimes it's automatically cancelled, and sometimes we can cancel the offer by using these ways. It's under section number 6. Number 1, notice of revocation. Notice of revocation means you have made an offer. Before acceptance comes to you, you can send another notice and say this offer is not valid. I have revoked the offer, right? So that's one way. It's lapse of time. There is a time given, for example, 2 days or 3 days, and the time lapse. For example, you have told someone to accept the offer for 2 days or within 3 days, and he does not come back to you within 3 days, the offer automatically revokes or cancels. He cannot come to you on 4th day, right? There are, for example, application deadlines. You see, when the deadlines is over, time is lapsed, no applications are accepted. Number 3, failure to fulfill conditions. As I earlier mentioned, there are If there are positive conditions with the offer and you fail to fulfill one or maybe more than one conditions, the offer is automatically cancelled for you. Death or insanity of offerer. Death means to die, and insanity means to become insane, right? The person who has made an offer, if he dies, that offer cannot be accepted. The person who has made the offer, he becomes insane, right? Again, the offer is invalid, the offer is revoked, so that revoked offer cannot be accepted. Revocation of offer by offeree. Sometimes when we make an offer, offeree cancels the offer and he rejects the offer. When offeree, the person to whom the offer is made, rejects the offer is automatically revoked, right? Reject means he does not agree with your offer, so offer automatically cancels. Number 6 is counter offer. Counter offer is different than the number 5. Counter offer is what? The opposite party is willing to come into dealing with you, but he has something else. For example, you have made an offer, he comes with another offer, so your offer is automatically cancelled or revoked. Now he has made an offer, you have to select, you have to accept or reject. For example, when we go to market and we buy, for example, a car from a car dealer. Car dealer offers us a price and we love that car and we want to buy, but the price is high. What do? We disagree with the price. We say, no, I don't want to pay this price. I want to pay this much price. So the first offer from the dealer's side is revoked, cancelled, because you have given a counter offer, another offer. Similarly, number 7 is death or insanity of offeree. Death, when the offeree, the person to whom the offer is made, he dies or he becomes insane, the offer automatically revokes and nobody else can accept the offer instead of him. Subsequent illegality. Subsequent means later. For example, you have made an offer. At the time of making offer, dealing in that thing, in that subject, is legal, but after you have made an offer, the law changes and it becomes illegal. When things become illegal, the offer automatically revokes, right? Even if the person has accepted, even if there have been some actions, right? You have to reverse those actions. You have to get in. Both sides should come to the parallel. Whatever has been obtained should be returned. Whatever benefit has been received, the same amount of benefit should be received by the other party as well. Or this benefit can be reversed back. So both parties come into the same status again, right? In case of subsequent illegality. Number 9 is destruction of subject matter. The subject, whatever was to deal in, to be exchanged, that subject matter, when that destroys, again the offer is automatically accepted. For example, you want to buy a house. You have made an offer to the house owner that I want to buy your house on this, and tomorrow that house burns or collapses, so your offer automatically revokes or cancels, right? Or for example, you wanted to buy a car. That car is stolen or gets an accident. What happens? The subject matter is destroyed. Now your offer is not in place. The offer is rejected. Prescribed manner. When an offer has prescribed manners for acceptance, means there is a way given, there is a prescription given, there is explanation given that through this way you have to send your acceptance, and we are failed to follow that method, that way, the offer for us is automatically revoked or cancelled. For example, I offer a job and request the candidate to send documents via email, and they brings to me physically. So they are not following the prescribed manner, therefore the offer for them is automatically revoked, so they cannot accept the offer, right? Okay, now let's talk about them in details. An offer can be revoked or cancelled by sending a notice of revocation to another party. It means that offerer may revoke his offer at any time before acceptance, even though the period of acceptance of offer has yet not expired. This way, the offeree cannot create a contract by accepting the revoked offer, right? For example, we have given an offer to someone, and we have given him 3 days to accept the offer or to let us know. On third day, right before he sends us acceptance, we have sent another notice for revocation of an offer. The offer legally revokes, so other party cannot accept that offer, and he cannot sue us in the court of law as well, right? Number 2, lapse of time. When the offer is kept open for a specific period, it terminates if it is not accepted within that period. If the offer does not specify any period, it terminates after lapse of reasonable time. The reasonable time depends upon the circumstances of each case. If a commodity is perishable, the reasonable time will be relatively shorter. So lapse of time is of 2 times. There are some offers having a specific time. After the specific time, the offer is revoked, you cannot accept. But there are some offers which does not have specific time. They are open offers, but there is reasonable time. After reasonable time, the offer automatically revokes. And reasonable time for perishable items or shorter is compared to unperishable item. Perishable means خرابیدون کی چیز خرابیگی زود که خراب میشه. For example سبزیجات و میوه‌جات و غیره. صحیح است؟ For example یک نفر است میگه که به شما 3 کانتینر کیلا است، یه رو میفروشم، به شما زنگ میزنه که برای ما احوال بدین و نمیگه که تا چه وقت احوال بدین. صحیح است؟ شما هم 3 روز باز میگین که شما گفته بودی و میخرم. او 3 روز برایتان منتظر شده نمیتونه، چون در 3 روز کیلا خراب میشه. صحیح است؟ شما باید خودتان بفهمین که چقدر زودتر باید او را جواب بدین و اگر جواب نمیدین او خودش آفر ریووک میشه، چون در 3 روز خراب میشه، خراب شد به او تاوان میشه. او که شما احوال نمیدین، مثلا در 1 روز احوال ندین، او میتونه که سر کسی دیگه بفروشه. صحیح است؟ خب that's about the lapse of time. Next, failure to fulfill condition. If an offer contains some condition and the offeree fails to fulfill these conditions, the offer terminates. Right? For example, Ahmad offers to sell his scooter to Bilal for 50,000 if Bilal gets admission in medical college. Right? This is the condition. Right? That if Bilal gets admission in medical college, Ahmad will sell his motorcycle 50,000. So Bilal fails to get admission, the offer is revoked. Understood? Okay. For example, a company offers to its employees that if their employees get admission in the university and they get, for example, 80% marks, they will pay their 50% tuition fee. So if someone does not get 80% of the marks, he cannot accept this offer. This offer is not for him because he could not fulfill the condition. The condition was to get 80% marks. Right? Next one is death or insanity. An offer terminates on death or insanity of the offerer if an offeree comes to know that the death or insanity of offerer before his acceptance. If the offeree does not know about the death or insanity of offerer and gives his acceptance, it's valid acceptance. It results in valid contract, and legal representatives of the deceased offerer will be bound by the contract. There is a point we have to remember. When the person who makes an offer dies before the acceptance of the offer, the offer is revoked. But if he dies after the acceptance of the offer is not revoked. Similarly, same cases with the insanity. Then who will carry out the contract with the offeree, the person to whom the offer is made? The legal representatives of the offerer, of the person who has died, right? But if the contract is of the personal nature, then this offer is automatically revoked, right? For example, Ahmad offers Bilal to paint him a picture, right? Before Bilal accepts the offer, Ahmad dies. This offer is revoked, right? But if the offer is accepted and after the acceptance of the offer Ahmad dies, then the legal representative of Bilal, who are expert enough to paint the picture, will carry on the contract. If they cannot, then the offer is automatically revoked. Similarly, we have revocation of offer by offeree. If offeree rejects the offer and communicates the rejection to the offerer, the offer terminates even though the period of acceptance of offer has yet not expired. For example, we have given 3 days to someone to accept or reject our offer. He comes back to us within 1 hour and says, I don't want to buy. So the offer is rejected, right? For example, we have offered someone a job, right, and told him to respond to us in 3 days. What happens is that he responds us in 3 hours and said that I don't want to work with you, right? So the offer is rejected automatically. Number 6 is counter offer. When an offer is accepted with some changes in the terms of the offer, such acceptance is called counter offer, and offer terminates when counter offer is made. The party making a counter offer cannot accept the original offer, right? For example, you say that I want to sell this laptop for example, for $1,000. You say I want to buy, but it's not $1,950. So this $950 is the new offer. The first offer for $1,000 is rejected because the new offer is called counter offer. Number 7 is death or insanity of offeree. An offer can be accepted only by the offeree. It cannot be accepted by his legal representative upon his death. If the offeree dies or becomes insane before acceptance, the offer terminates. After acceptance, the offer is okay then, right? For example, someone makes somebody an offer and before the acceptance he dies or becomes insane, the offer is revoked. But when he accepts the offer and the acceptance is communicated with the offerer, then the offer is okay because the promise is already created. Then the legal representatives of the offeree will continue with that contract with the offerer. Next is subsequent illegality. An offer lapse if becomes illegal before its acceptance. An offer may also terminate if it becomes illegal due to change in law because its acceptance before its acceptance by the offeree. So if the offer is not accepted yet and the law changes, there are legal changes, so the offer automatically revokes. But if the offer is accepted, then the offer has turned into the promise. It should be fulfilled accordingly. And as I earlier mentioned, that if Allah does not allow to perform the contract, then you have to stop there and you have to benefit as much as you are benefited. You have to benefit the other party as well. Next one is destruction of the subject matter. An offer lapses if the subject matter of the offer is destroyed before its acceptance by the offeree. Even if it is accepted that the subject matter is destroyed, the offer is revoked. Number 10, prescribed manner. If the offer prescribes the manner of acceptance, the offer terminates if the offeree does not accept it according to the prescribed manner. If the offerer wants to reject the offer, he must inform the offeree within a reasonable time to offer. If offerer does not inform, he will be bound by such acceptance, right? So prescribed manner are important. If you are given, the ways for acceptance of the offer, and we does not fulfill those, we does not act upon those manners, those ways of accepting the offer automatically rejects. So that's all about today's lecture. Inshallah, I'll get back to you with another lecture. If you have any questions, please do let me know. Thank you very much. Wassalamu alaikum wa rahmatullah.